Hi, it's Rory Clark with the Legacy Elder Law Center, and today I'm here to give a video blog on a program called VA Aid and Attendance, which is a long-term care benefit available to wartime veterans and their surviving spouses. It's a thank you program like the GI Bill that extends not only to our wartime vets but to their surviving spouses in appreciation for the service they provided to the country. The benefit is exciting because it's tax-free. It doesn't require that you go to a VA nursing home or a VA assisted living facility. It is cash deposited into the veteran or the surviving spouse's account, and it can be used for any purpose to help support their financial needs. At the higher end of the benefit scale, a veteran with a spouse, it pays about $2,300 a month, tax-free. That's about $26,000, $27,000 a year, tax-free. The benefit for a surviving spouse, even after the veteran has died, is about $1,250 a month, tax-free, around $15,000 a year. So this can be just perfect to help, in addition to regular income, meet the financial strains of having care come into home or a place like assisted living. There's three eligibility requirements I want to tell you about for this program. There's service eligibility, medical eligibility, and financial eligibility. So let's hit all of those. Before 1980, and that's the era that we're looking at right now, our veteran needs to have served 90 days on active duty, 1 day during a period of wartime, that's it, and not have been discharged dishonorably, okay? So those are the eligibility requirements for the veteran. If we're talking about a surviving spouse, I simply need to prove that the veteran would have qualified and that the spouse was married to that veteran for at least 1 year. So that's service eligibility. Medical eligibility got much simpler with some new regulations about 3 years ago from the Department of Veterans Affairs. Under the new rule, there's two prongs. First is the applicant over 65 years of age? And second, does the applicant's own personal doctor, not the VA, say that the person needs help to be safe? That really is the core of the definition. So it's quite straightforward, and it means this is widely available to people who need assistance as they age. Finally, the last eligibility requirement is financial assistance. There are some rules that basically push families to plan. The first one is an income rule that basically stands for the proposition that families that are spending their regular income on care and have less money for things like food and shelter are going to get this supplement to replace those losses. So there is an income test that says that you need to be incurring unreimbursed medical expenses that meet or exceed your regular monthly income. And the second is a net worth test that's designed to encourage people to plan ahead to protect themselves and to protect their families. Bottom line is, we can shelter an unlimited amount of assets, $50,000, $500,000, $5 million in an appropriately designed asset protection trust. And as long as we create that more than 3 years before the person needs to file an application, they'll meet the eligibility rules. The bottom line eligibility rule is if there's a net worth of less than $130,000, not including our applicant's personal residence, any vehicles, or any assets sheltered in one of these trusts, they meet the eligibility rules. So this can be a very, very powerful tool and a very, very powerful thank you for those who've served the country. Hope you found this informational. If you like this kind of education, please come and join us on our website at legacyelderlaw.com. Go to the menu and select Education, and you'll find lots of other topics with great information like this video blog today. Thanks for joining me, and I look forward to seeing you again soon.